Your Honour, if I can just wrap up the point on constitutionality. The issue really is whether or not this court should refer the matter to the Union Supreme Court for its determination. It's said against us that you have to be convinced of the unconstitutionality of the legislation before you can make a reference. And that's said on the basis of the authority of Fisker and Furman against Furman and Peruzzi. If I could just take Your Honour to that case for a minute. I believe that is at tab 1 of the claimant's authorities. And if I could take Your Honour to paragraph 45.
I'm sorry, I didn't hear that.
Paragraph 45. The learned judge there sets out the text of Article 55 of the USC law. It should be 58. And he then goes on to say, this means that this court has the capacity to consider the merits of the application and determine whether a conflict exists between two or more laws that fall under the jurisdiction of the USC. But the question remains as to what extent the referring courts do usually stand. The answer to this question can be found in case number 134, constitutional of 9th June 2008, presented to this court by the defendants in the hearing, not part of the authorities' bundle. Your Honour, we've looked for that case and we haven't been able to locate it, unfortunately. But as I understand it, my learned friend Mr. Montague Smith acted for the defendants of that case. So if they thought it had any relevance to the issues before this court, no doubt they would have produced it. But in any case, he then goes on to quote from that case, the court has the authority to evaluate whether the pleading of non-constitutionality is serious or not. And he then goes on, that leads this court to the conclusion that the party pleading a challenge of non-constitutionality of a certain law must plead before this court to a certain level of seriousness, and that, in my view, should be the same level as would be pleaded before the USC. Moreover, the judge considering the challenge would have to be convinced at the same level as the USC. Now, my learned friend would have you believe that in finding, as he does in paragraph 48, that the judge considering the challenge would have to be convinced at the same level as the USC, that you have to be convinced of the unconstitutionality of the legislation before making the reference. We would say that is interpreting the paragraph wrongly. What the judge is really saying is that you must be convinced of the seriousness of the plea to the same level as the USC would be if it were hearing the argument. He isn't saying you have to be convinced of the constitutionality. He is dealing with the seriousness of the plea. And that is underscored by his use of the phrase to the same level twice. So we would say that that case doesn't operate to bar you in any way from referring this matter, even if you're not convinced of the constitutionality of the unconstitutionality of the USC legislation. We merely have to persuade you that there is a serious point here. And in my submission, you've done that.
Where is the authority for the proposition that it's enough to persuade the court that there's a serious point? Is that contained in any piece of legislation or code or what?
No, Your Honour, the provisions of the Union Supreme Court law, which are at tab 14 of this bundle, they merely provide that requests for examination of constitutionality, as Article 58, to be raised before the courts in respect of a case being tried by such courts, shall be referred to the Supreme Court by virtue of a grounded decision from the court to be signed by the President of the competent court. Such decision shall have the text to be examined, if reference is made upon a decision from the court of its own accord. So that's a reference made by the court of its own accord. It has to be based on a grounded, I think the better translation would be reasoned decision. The second paragraph, whereas if the challenge of lacking constitutionality is raised through the plea of one of the litigants in the lawsuit, and the court has admitted such challenge, it shall fix a term for the challenger to submit the challenge to the Supreme Court. If the term expires without the challenger having submitted evidence indicating that he has lodged his appeal in time, he shall be considered as having relinquished such plea. So this paragraph only requires that the court admit such challenge. It doesn't say anything about seriousness or otherwise. And it does provide that if the court rejects the plea, the rejection shall be pursuant to a reasoned judgment. So it provides the basis on which a plea should be rejected, but not the basis on which a plea should be accepted.
Is the plea of unconstitutionality, or is the plea that this is a matter that ought to go to the Supreme Court?
Well, our plea is that
On the wording of Article 58. What's meant by it, and the court has admitted such challenge in the second paragraph? Does that mean that the court accepts the contention that there is unconstitutionality, and then refers the matter to the Supreme Court, which has exclusive jurisdiction over the question of whether there is unconstitutionality, or is something else meant by the admission of such challenge?
Your Honour, in my submission, it means simply admitting the challenge as being a valid one, and admitting the challenge as a challenge, rather than as one that is bound to succeed.
Could we just look at the third paragraph?
Of course. Your Honour, I think it must be the Court of Appeal of either the mainland courts or in the DIFC Court of Appeal. Because I don't think there is a route for a petitioner to get directly before the Supreme Court. And I believe there is Supreme Court authority to that effect.
So there is the route to the Supreme Court, an appeal from the final Court of Appeal within the court system once returned, either the mainland courts or the DIFC court.
I think the only route that an individual petitioner has to get to the Supreme Court is if the court refers the matter. I don't think he can go directly to the Supreme Court if his appeal is rejected.
Yes. Perhaps that takes us back to paragraph 1. Let me just look at that again. Paragraph 1 clearly confers jurisdiction on a lower court to make a reference. And the rest of the paragraph contemplates situations where no such reference is being made at the instance of the initiative of the court.
Your Honour, yes. The rest of the article.
It looks as if it looks as if it's for the court below, either the mainland court or the DIFC court, to decide when it's appropriate to make a reference to magnetism.
Your Honour, yes.
Your submission, as I understand it, is that if there's a better than frivolous argument, a serious argument,
Your Honour, yes.
that it's maybe unconstitutional, then the court ought to make the reference. But there's no compulsion on the court to do so. Just remind me of the situation concerning EC law in England and Wales. Do I remember correctly that the only court compelled to make reference is the Supreme Court?
It's the House of, yes.
And for lower courts, it's a matter for individual decision. But there'll be some guidance there as to when the lower it's appropriate for the lower court to make a reference.
Your Honour, yes.
Yes.
And that's where the... No, well, that's where the doctrine of Act Clare tends to into the picture.
Yeah. Yes. If a reference is made, does that will cut out all the appeal from expressing issues, it will go leapfrog straight
Your Honour, we would say on the wording of Article 58 no, because the rejection of the plea for the reference has to be made on a reasoned basis. And the reason that your appellate court may decide differently is, we would say, not a good reason if the court is itself satisfied that the reference should be made.
Well, slightly what I meant is whether it could be appropriate for the court in first instance when deciding to consider whether the Court of Appeal ought to express its views so that the Supreme Court has the benefit of the Court of Appeal's reasoning as well as the Court of First Instance.
Your Honour, unfortunately there is no express guidance on these sorts of issues. We only have the texts of the Constitution, Article 99, which provides for the reference to the Supreme Court in issues of constitutional matters, and Article 58 of the Union Supreme Court. And there is just this one judgment, Fruze and Furman, in which the matter is being dealt with by His Honour Justice Al-Madani. Now, going back to that judgment, the word serious is taken from the case that we've been unable to find. And he says in paragraph 47, the answer to the question, that is, to what extent the referring court's view should stand, can be found in this case, where the court has the authority to evaluate whether the pleading of non-constitutionality is serious or not. Of course, that's a slightly different point from whether it should refer to the Supreme Court. But that's the only guidance we have. But the point that I'm really at pains to make before Your Honour is that we don't need to convince you that our argument is correct before you have the power and indeed, we would not say the obligation, but the authority to make a reference. We simply need to convince you that our argument is serious, or that it is more than frivolous, as you put it yourself.
Well, that would be a necessary, but perhaps not sufficient position.
Your Honour, yes. To the extent that there's any other guidance on this, there is a decision of the Supreme Court which is at tab 2 of the Defendant's Authorities budget. That is slightly different because it concerns a request for interpreting the Constitution as opposed to a request that the Union Supreme Court determine whether or not legislation is unconstitutional or otherwise. But we say that because this issue is tied up with the interpretation of the Constitution, you can take some guidance from the words here, which are to the effect that if there are differing opinions on the interpretation of the Constitution, a reference should be made. Your Honour, I'm afraid the passage which I've quoted in my skeleton is not immediately jumping out at me, and I haven't highlighted it. But,
You come back
okay.
at any time. So don't take up further time looking for that. We'll come back to it.
What they say is that it is sufficient that more than one opinion revolves around a constitutional text, in a way actuating its judgment as per the wish and purpose of who made the Constitution, to justify referring to the court and getting rid of the mystery of this field, in order to guarantee the unity of the application and stability of the Constitution. Those referrals are, of course, referrals from UAE governments and other authorities of the UAE. But we would say that to the extent that this case raises an issue of interpretation, that guidance should...
Yes, absolutely. So I would be like, for example, you could just take me to the specific part so that I can answer the job. But I've got it in your skeleton in the meantime. Yes, let's certainly move on.
Your Honour, yes. Now, the next head of our jurisdictional challenge, and it operates also as a defence of the immediate judgment application, is that this particular judgment, it's a very peculiar form of judgment. It's a confession judgment. It's not, it doesn't engage any lists between the parties at all. There is no litis contestatio, and it is simply entered by an administrative act. There's no judicial involvement in the entry of the judgment whatsoever. Now, we would say in those circumstances, it doesn't constitute a judgment at all for the purposes of the jurisdiction to recognise and enforce judgments. That it is called a judgment, or a judgment by confession, or a confession judgment, doesn't alter its nature as a matter of English law, as to whether it's a judgment that is deserving of recognition and enforcement. And we rely on the authority of ex parte more in re faithful, which is at tab 4 of our bundle. In which the Earl of Selborne, Lord Chancellor, says, and this is at page 5, to constitute an order of final judgment, nothing more is necessary than that there should be a proper litis contestation and a final adjudication between the parties to it on the merits. And the judgment of the Master of the Rolls, Mr. Justice Brett, if I could just ask you to read that briefly to yourself.
Yes, I will.
in particular where he says it is a judgment in an action between parties brought to establish some right of plaintiff against the defendant. We say there has to be an action between the parties before there can be a judgment, properly so called. Now, by the very terms of the New York rules, Rule 3218, there is no action before the entry of a judgment by confession. So in those circumstances we say it doesn't meet the English test for being a judgment at all. Furthermore, Rule 3218B, which is a necessary part of the rule, provides that the judgment may be docketed and enforced in the same manner and with the same effect as a judgment in an action in the Supreme Court. Now, this is a slightly double-edged point, because the issue is that the New York law deems the judgment to be enforceable in the same manner and with the same effect as a judgment in an action in the Supreme Court. Our argument is that, but for that provision, the judgment plainly would not, as a matter of New York law, be enforceable in that way. It is only because of that provision in New York law that it becomes enforceable as though it were a judgment in an action in the Supreme Court. That, of course, is not law in the DIFC. To the extent that the DIFC law is based on the English law is that the judgment must be based on an action.
But I'm unaware of any decision in the English courts involving a foreign judgment where the judgment debtor has agreed that the judgment resulting from the stipulated process will be enforceable in foreign court. The scrutiny of the judgments which, under English law, the court undertakes before deciding to enforce them is to be concerned to see that this gives rise to an obligation that really in all fairness as having regard to broad questions of justice should be. Now, where the judgment debtor has agreed that there will be a judgment of the court which under the local jurisdiction will be an enforceable judgment, and that judgment will be enforced in foreign courts. The concerns that underlie scrutiny that is undertaken by the English courts are dealt with, aren't they?
Well, Your Honour, we would say this case demonstrates that they are not, because the judgment may be entered on an improper basis, and the judgment debtor is not consenting to an improperly obtained judgment being enforced in other jurisdictions. It is only consenting to a properly obtained judgment being enforced in other jurisdictions. But that doesn't detract from the proposition that the judgment is not, as a matter of English law, properly described as a judgment at all. So you could have many situations where a party can...
I'm trying to make a point that there is that jurisprudence as to whether the judgment to be enforceable should be the outcome of contest. It's all in it's always in cases where there has been no agreement.
Your Honour, I see the force of the point. The answer to it is that that solemnly given agreement is given on the basis that the judgment is properly entered. And if it is improperly entered, as we say it has been here, then that solemn agreement has no meaning whatsoever.
Well, that goes to whether or not the court ought to take cognizance of the applications being made to the New York court to vacate the judgment. And the general approach is that the judgment is final and conclusive, even though it may be subject to an appeal, but there may be room for the grant to stay. And the similarity with the enforcement of arbitration is also striking. In fact, where an award, the enforcement of an award may stay, sometimes on terms of security, to allow a challenge to the award to progress. But otherwise, the award is the award, or the judgment is the judgment. See, who knows whether or not your argument assumes that this has been improperly procured judgment, makes that assumption, which is very strongly contested. And this court can't make a, and it's not the place to make an ultimate finding of that.
No. Your Honour, I think the argument as to whether or not it constitutes a judgment is specific to the nature of a confession judgment. And regardless of the party's agreement to its enforceability, if it is not an enforceable judgment, the parties can agree to recognise something that is. How can you agree to recognise an unenforceable judgment? It really becomes.
Look at this day and age. In the community of commercial courts, around the world, the instinct of the court is to have regard to the circumstances which have led to the judgment. So we look to see whether or not the original court had jurisdiction according to our international views of jurisdiction. And we may have regard to other matters if the judgment is manifestly an unfair judgment of the product of an unfair procedure, then it might not be enforced. And what you have to face up to is to be considered whether this ought to be treated as a judgment whether you enforce it. The solemn agreement of the law is an important fact. I don't think you can pretend that it isn't.
No. It is an important factor, Your Honour, but we would say not the overriding factor.
Well, if it isn't the overriding factor, if it is the overriding, sorry, if it, on your case, if it isn't the overriding factor, and instead the questions of context are the overriding factor, then this would not be a judgment that the court would court has made this approach, and you accept that in making it straightforward, it would be legitimate for the court to have regard to the consent that your client gave in exchange for an extremely valuable consideration.
Your Honour, yes, but if I may put it this way, my clients might have consented to the enforcement of the act of an administrative officer. That doesn't make that act a judgment that is enforceable by a foreign court, simply because they consented to it. So that they've given their consent is not really material on our case to the issue of whether or not, as a matter of English law or DIFC law, the pronouncement of the court in question constitutes a judgment.
What does it mean when it is specified or agreed that the judgment resulting from a confession, an affidavit of confession, shall be enforceable in foreign court? Is that a meaningless undertaking or obligation?
Your Honour, I'm not really in a position to say because I'm not qualified in New York law. As a matter of the United States, foreign courts could be the courts of other states of the United States.
Well, it's clear, isn't it, from the word of the confession of what is contemplated. It is not just states within the United States. It's perfectly clear that it extends beyond that. I don't think you ought, with respect to you, I don't think you ought to take such a technical approach. It just doesn't chime with the merits. It's an extremely technical argument. You have ceased to make any payments at all in respect to the obligations you were to the claims. Don't you?
Your Honour, yes.
Yes. And yet, clearly, under the guarantee, you owe a very large sum of money. And here you are making this highly technical, and if I may say so, highly unattractive argument, which avoids inviting the court to shut its eyes to the solemn obligation that your clients undertook for a very valuable consideration given the position they're in.
Well, Your Honour, you have my submissions on the point. Now, the next point we make of the judgment is that it is not final and conclusive. In this respect, we rely on the case of Nuvion and Freeman, which is at tab 5 of our authorities file. Nuvion and Freeman concerned a remate judgment, which is a particular Spanish form of judgment, which can then be reviewed in a plenary action, as it's put, in plenary proceedings. And in those plenary proceedings it has no standing whatsoever, and it can be entirely set aside and a different judgment can be entered. At page 6 Lord Herschel, the beginning of the final paragraph on that page, sets the scene. He says, it is necessary to state distinctly what the nature of that judgment is, because I think it will be found that the decision of your lordships must be determined by that consideration. So having set that scene, he then goes on at page 8, at the very bottom, but it was conceded, and necessarily conceded, by the learned counsel for the appellant, that a judgment to come within the terms of the laws as properly laid down must be a judgment which results from an adjudication of a court of competent jurisdiction, such judgment being final and conclusive. He then goes on, they contend that this judgment is final and conclusive, and no doubt in a certain sense that must be conceded. It puts an end to and absolutely concludes that particular action. About that there can be no manner of doubt. In that sense it is final and conclusive. But the same may be said of some interlocutory judgments upon which there can be no question that an action could not be maintained. They do settle and conclude the particular proceeding, the interlocutory proceeding, in which the judgment is pronounced. It is obvious, therefore, that the mere fact that the judgment puts an end to and finally settles the controversy which arose in the particular proceedings is not of itself sufficient to make it a final and conclusive judgment upon which an action may be maintained in the courts of this country, when such judgment has been pronounced by a foreign court. My lords, I think that in order to establish that such a judgment has been pronounced, it must be shown that in the court by which it was pronounced, it conclusively, finally, and forever established the existence of the debt of which it is sought to be made conclusive evidence in this country, so as to make it res judicata between the parties. If it is not conclusive, in the same court which pronounced it, so that notwithstanding such judgment, the existence of the debt may between the same parties be afterwards contested in that court, and, upon proper proceedings being taken and such contest being adjudicated upon, it may be declared that there existed no obligation to pay the debt at all, then I do not think that a judgment which is of that character can be regarded as finally and conclusively evidencing the debt, and so entitling the person who has obtained the judgment to claim a decree from our courts for the payment of that debt. The principle upon which I think our enforcement of foreign judgments must proceed is this, that in a court of competent jurisdiction, where according to its established procedure, the whole merits of the case were open, at all events, to the parties, however much they may have failed to take advantage of them, or may have waived their rights, any of their rights, a final adjudication has been given that a debt or obligation exists which cannot thereafter in that court be disputed, and can only be questioned in an appeal to a higher tribunal. In such a case, it may well be said that, giving credit to the courts of another country, we are prepared to take the fact that such an adjudication has been made as establishing the existence of a debt or obligation. But where, as in the present case, the adjudication is consistent with the non-existence of a debt or obligation which is sought to enforce, and it may thereafter be declared by the tribunal which pronounced it that there is no obligation and no debt, it appears to me that the very foundation upon which the courts of this country would proceed in enforcing the foreign judgment altogether fails. We also would rely on a passage at the bottom of page 10, beginning, then my lord, it is said that such judgment is analogous to a judgment which has been obtained upon which a suit may be instituted in the courts of this country. You are ungrateful. And turning to the speech of Lord Watson over the page, page 13, about 2/3 of the way down, begins, in order to its receiving effect here, a foreign decree need not be final in the sense that it cannot be made the subject of appeal to a higher court, but it must be final and unalterable in the court which pronounced it. And if appealable, the English court will only enforce it subject to conditions which will save the interests of those who have the right of appeal. And then at the bottom of the page, beginning, in my opinion, there is no real difference, to the end of his speech. And then the passage in Lord Bramwell's judgment, beginning, then, as my lords, if so, this is what I may call, for want of a better expression, a defeasible judgment, that is to say, the defendants who are subject to the order that execution may issue may take proceedings which would have the effect of defeating or nullifying or making an end of the judgment or order which has been pronounced, that execution may issue.
Yes.
And over the page, there's a passage that begins, but there is no such presumption here. On the contrary, we learn that it is possible not merely that what was decided in the court may be nullified, but that there may be questions raised before the parties which could not be decided in the formal proceedings. There is an essential difference, therefore, between the case where a court of competent jurisdiction has entertained all the controversies between the parties which they could and chose to raise and come to a conclusion which is presumed to be accurate, and this case where there is no ground for saying that all possible controversies between the parties have been decided. And then finally on page 16, he says, if we should give judgment for the plaintiff here, he would be better off than he would be if there were a mere affirmance of the judgment with all its consequences in Spain, because in Spain the judgment that he has got is liable to be defeated. But if judgment were given for him here, there would not be that liability to be defeated by proceedings being taken here analogous to the plenary proceedings in Spain. Finally, the judgment of Lord Ashbourne, page 17. About 2/3 of the way down, page 17, it was not a judgment upon a claim which could be met by pleas upon the merits, going exhaustively into all the topics upon which the defendant was entitled to rely if he had the wide scope open to him, which in any plenary suit a litigant would have. Therefore, in no sense can this be regarded as an adjudication in a cause where the merits were or where they could be tried. And I'm not aware of a single precedent where in this country effect has been given to a foreign judgment so obtained. Your Honour, we rely on those passages as showing that the judgment of the Court of New York, to the extent that it is subject to the motions to vacate, it remains quite possible that, I quote from the words of Lord Herschel, it may thereafter be declared by the tribunal which pronounced it, there is no obligation and no debt. And in those circumstances, it cannot be enforced as a foreign judgment in the DIFC courts. As we say, it isn't the fact of the existence of the procedure, it's the invocation of that procedure that makes it a non-final and conclusive judgment. The learned friend says it is final and conclusive as a matter of New York law. But we say that isn't really the test. The test is whether, as a matter of English law, it is given res judicata in the country in which it's issued. And the test is set out in Nuvion and Freeman, quite extensively dealt with. And it's quite plain that this judgment may well be undone if the motions to vacate are successful in New York.
Supposing you had a foreign judgment that was the outcome of a full contest, leading to a fully reasoned judgment in favour of plaintiff for a specified amount. And upon an application of enforcement in, let's say, DRFC 4, it is alleged that the judgment was procured by fraud, that witnesses were bribed and so on. Would that judgment nonetheless be regarded as a filing of a conclusive judgment to facilitate the argument?
Your Honour, yes, it would, because it is final and conclusive, it's dealt with the merits, and it isn't reopenable in the court which pronounces it.
That's not quite necessarily quite right. I'm trying to speak from some experience. I tried a personal injury case where the claimant had been very seriously injured. And I made a large award of damages. The insurance company then conducted a secret survey of the claimant and said that the films that the secret could take of his activities showed that the judgment had been procured by his dishonest evidence. And the Court of Appeals said that the trial judge should determine whether or not there was such fraud. So it is entirely conceivable that the court gave the judgment could be the court that sets it aside. But until the judgment is set aside, it would be regarded as final for the conclusions of the judgment.
Well, Your Honour, in the example which you've given, it's debatable whether or not the merits are properly gone into if there was some form of fraud which misled the court as to what those merits were. So the issue becomes a difficult one, really, because absent the merits having been investigated properly, the finality and conclusiveness of the judgment must remain open to question.
But is that the approach that English courts take? My recollection is that unless it can be clearly demonstrated on an application without having to be in effect a trial, that the judgment of the court of the travesty, that the judgment is final and conclusive for the purposes of enforcement. And the judgment debtor can bring an action seeking to set aside the judgment or seeking damages on the basis of its allegations of fraud. Now the court may have a jurisdiction to stay the enforcement of a judgment depending on the fact of fraud. But as to the question of whether the judgment satisfies the tests of being final or conclusive, it would satisfy.
The question is finality and conclusiveness from the point of view of its enforcement as a foreign judgment, as opposed to its enforceability in the jurisdiction in which it was given. And from that perspective, if it can be reviewed by the court which issued it, it is not final and conclusive.
But almost all civil rights courts would allow for a proceeding to overturn a judgment to be reviewed by a court. So the fact that that is a possibility within the jurisdiction from which the original judgment issued can't be a reason for concluding that the judgment isn't final or definitive.
The mere fact that it's a possibility is not. But the fact that it is actually being alleged and that it's being proceeded with, it puts the finality of the judgment into question.
What's the difference then between the situation you're postulating and where there is an appeal? And we know that the fact that there is an appeal does not render the judgment unenforceable by reason of it not being final or definitive.
An appeal is against the reasoning and the judgment and its findings as a result. Whereas the reopening of the decision by the court which issued it is simply the court reviewing its own decision. It isn't saying I got the reasoning wrong, or so to that extent the fact of an appeal doesn't in any sense render the original judgment any less final or conclusive. Moving on, we also say that the confession judgment is not one on the merits. Now that is plain to see on the face of it. There is no investigation of the facts. There is no recitation of the legal principles of law on which those facts are determined. And it was said by Lord Brandon in the Essar that a judgment on the merits is a decision which establishes certain facts, proved or not, in dispute, states what are the relevant principles of law applicable to such facts, and expresses a conclusion with regard to the effects of applying those principles to the factual situation concerned.
But imagine in this case, a claim is issued, and the defendant issues a defence admitting liability. And then is there a judgment on omissions? And that judgment is sought to be enforced in the foreign court. Is it your submission that it would be unenforceable because of what Lord Brandon had to say?
Your Honour, a judgment by confession, by consent, or by admission is, yes, in my submission, unenforceable, because that is the effect of the authorities.
But it has there been cases for these courts where it has been held that a judgment resulting
Your Honour, I don't think there's been a case directly on point, but the authority that I refer to, Serious Fraud Office in Sally, makes it quite plain that a judgment by consent is not a judgment on the merits, as there's been no adjudication between the parties. And we can have a look at that authority. I think it's in the claimant's authorities bundle. At tab 26. If you go to paragraph 69,
But can you just tell me what this is all about? How does this come before the court?
this came before the court on the grounds that the respondent was subject to a property freezing order under Part 5 of the Proceeds of Crime Act. Her argument was that the matter had already been determined by the US courts, the Canadian courts, which she said operated as a judgment that prevented the English courts dealing with the matter. So the issue, or one of the issues, is whether or not she had consented or agreed to the Canadian court's order, or whether actually the administrators in Canada had agreed to that order being withdrawn. And it's in that context that the
property is made subject to a freezing order on the basis that the property constitutes proceeds of crime. Is that right?
Your Honour, yes.
And the freezing order is challenged on the basis that the property in question was not in fact the property of the respondent.
Your Honour, yes, I think it is challenged on the basis that the relevant authorities in Canada, in obtaining a judgment against the person subject to the freezing order, had withdrawn the allegation that it was her property.
Right. There had previously been an order in Canada made on the basis that it was not.
Your Honour, yes.
Right. And then when we look for what part is this judgment taking?
If I can start at paragraph 69 under the heading Res Judicata. Justice Andrew sets out in paragraph 70, the relevant rules in respect of the recognition of foreign judgments are well established and are largely uncontroversial. A foreign judgment which is final and conclusive on the merits is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any error of fact or law. This principle, reflected in Rule 48 of Dicey, applies with equal force to foreign judgments in rem as it does to foreign judgments in persona. So He plainly is of the view that the judgment has been I beg your pardon, yes. Lady Justice Andrews plainly of the view that the foreign judgment must be final and conclusive on the merits to be subject to recognition and enforcement. She then goes on, paragraph 78. A decision on the merits, as explained by Lord Brandon and the Senate, means that it is a decision which establishes certain facts as proved or not in dispute, states what the relevant principles of law applicable to such facts, and expresses a conclusion with regard to the effect of applying those principles to the factual situation concerned. In the same case, at 4980C, Lord Diplock, who agreed with Lord Brandon's conclusions and reasons, added that the moral overtones which the expression on the merits tends to conjure up may be misleading. What it means in the context of judgments delivered by courts of justice is that the court has held that it has jurisdiction to adjudicate upon an issue raised in the cause of action to which the particular set of facts give rise, and that its judgment on that cause of action is one that cannot be varied, reopened, or set aside by the court that delivered it or any other court of coordinate jurisdiction. And then paragraph 79 over the page. A judgment or order on the merits will not include an order dismissing a case for want of prosecution, or for a technical objection, or for a default of pleading, nor will it include an order made by consent, for the obvious reason that even if it gives its approval to the agreement made between the parties, the court has not itself adjudicated upon the matters in issue between them. The position in respect of foreign judgments entered into default is the subject of some academic debate, which it is unnecessary to rehearse for present purposes, since I am not concerned with a default judgment. So we rely on that as authority for the proposition that a consent judgment, which is the same effectively as a judgment on admissions, cannot be one that's on the merits and therefore recognisable and enforceable by a foreign court, or by the English court if it's the judgment of a foreign court.
Well, this is first instance authority as to a consent judgment.
Yes.
Has there been any other decisions of higher authority that deal with a situation where a claim is made, the claim is admitted, and in the face of that admission there is a judgment?
Not so far as I'm aware.
Yes, Mark? What did she decide in the end?
I think she decided that the freezing order should remain in place.
Well, I have to understood how all that leads to this particular conclusion, but I shall have to come back to this chapter.
exists.
We resume at 2:05.
All right.
Just give me 1 second.